the speaker disqualified 21 people in the meantime. And the deputy speaker, with a session outside the precincts of the House, declared that to be void.
So the governor fixed the first item in the agenda as the removal of the speaker.
Yes. And said that you cannot change the composition of the House. In the meantime, it had already been changed because the speaker had already disqualified those 21. It is already changed.
Before 9.
Before the 9. So this then was the order of the deputy speaker, struck down by this court. The order of the governor preponing the session, struck down by this court. But more important than that, in the meantime, a new government had formed. Because these 14 members were declared to be continued to be members, they defected. A new government was formed. This time, this court, first time in the history of this court, in fact ensured a status quo ante and said, we will not tolerate this. Nabam Tuki became the chief minister for 2 days. And then somebody else, Khaliko Pul, he then defected and then he became chief minister. The point is, why did we have 10th schedule? We had the 10th schedule to serve the cause of political morality and to ensure defections don't take place. And now this very 10th schedule is actually subverting that. There was a time when 356 was misused, and by all governments. Today, the 10th schedule is misused by all governments. That's where we are. So you have to decide, whether you want to uphold Kyoto or the whole new system has to be put in place if you want to really serve the cause. Now, there's another shenanigan happening. Before, when you defect, we know that they are defecting, so all of them go to the speaker and resign. So that they should not be disqualified. Now, because they resign, then elections to take place, then they win, then they become ministers. That's another thing, Your Lordship, my Lordship, the Chief Justice has seen that happening in Karnataka, saw that happening in Madhya Pradesh. This is the new thing that's happening. So how is this going to work? And how does the notice to a speaker deny him? Let's look at it another way. There may be several disqualification petitions pending against several political members of several political parties. You may have a disqualification petition against a Samajwadi Party, a BSP person, a Congress person. So a Congress member, one MLA files a notice, he can't even decide the others. He can't deal with the Samajwadi Party or he can't deal with the BSP because he's disqualified.
Let us see those observations in this judgment.
I'm sorry?
Let us those observations. Yes. Like the resolution was passed and the resolution was to be considered for the disqualification of the certificate.
In this case, a notice was issued.
Resolution was also it was directed.
A notice was issued, and on the basis of that notice, on the 27th, a writ petition was filed 468 and 469. On the basis of that, it was stated that now that a notice has been issued, the speaker can't deal with the matter. True, it was later, the resolution was passed. So, on that basis, and the other thing that happened, two things happened. One, they said that you can't deal with the matter. Two, the speaker had given only 2 days notice to the MLAs. Second ground raised was that this 2 days is not enough. So these are the two issues raised in writ petition 468 and 469. And on that basis, on the 27th of June, this court said that we give them 12 days, we give them till 12th of July to file their reply. In the meantime, the government was talking.
Let's see how they formulated that,
I just wanted, my Lord asked that question, so I just wanted to respond to that. May I just point out here, they say through a notice of resolution. Actually, this is inaccurate language. It is a notice to move a resolution. It is not a notice of resolution. It is a notice to move a resolution for the removal of the speaker. Because that resolution is moved only when the House gives leave. So this is completely inaccurate.
Under the proviso.
Yes. Well, if these disqualified members are disqualified, then they would not be in majority. Then this consequence would not happen.
Right.
Well, I don't understand this statement either. It can take 6 months. if you issue the notice, just after the session is over, and the next session is within 6 months, it takes 6 months. Which means there's a hiatus in the functioning of the constitutional authority. So how did the court say it will take no time at all? It will take no time at all, if the leave is granted in the House and the resolution is put to vote. Then it's no time at all. So my argument before your lordships is going to be the following. Let me state by state that a notice for removal of the speaker should only be moved when the House is in session. That will prevent all this malpractice that takes place. It's a proposition that my learned colleague Uddhav suggested to me, and I found it appropriate. Otherwise, what happens is that you can topple governments at your will, knowing the nature of our politics. But if it is allowed to be moved only when the House is in session, and if leave is granted and within 7 days it has to be put to vote, then none of this will happen. Then the 10th schedule will be allowed to function. And also the speaker, when the resolution is passed, till such time as the resolution is passed, he continues to be a speaker of the House. He only vacates his seat when the resolution is put to vote.
Otherwise, according to the consequences, the moment a notice of resolution is issued, he becomes disabled.
Yes.
It's a constitutional office.
Yes, it's a constitutional office. There can be no hiatus. There can be no pause.
The rules of the legislative assemblies indicate how many members have to move a notice.
29.
29.
20.
All assemblies.
No, they are different. Rajya Sabha is different. Lok Sabha is 59.
29 is the number under the rules.
Yes, under the rules of business.
So that's
10%.
Where does the 10%
Where do you get that?
under the rules?
In the
Rule 11 says 29.
Oh,
Rule 11.
different assemblies will have a different threshold.
Yes, every assembly will have.
every assembly would have a different.
There's no
There's no minimum. No. For example, in Rajya Sabha, in Lok Sabha, it's 50.
Or
Rule 20.
So the notice can be given by one person.
Which rule is this? Rule number?
Rule 11. Rule 11.
The whole process, according to your submission should be completed in that session.
That's right.
No, the concern rule, answering your question, concern rule is at page 40. Page 40, statute compilation. My learned friend is right, the figure used is 29, but the logic is 10% because the membership of this house is 288. So the nearest round.
so Rule 11 says 10%.
It is not notice, it is leave to move the resolution. Notice is by one person.
Correct. Unless it is supported by 29 MLAs, correct? It is not a resolution at all.
Yes. Not only that, but he may not move it.
And only
what has happened in this case, that resolution has never been passed, 8 months have passed. He only did it to ensure that the speaker doesn't pull his act under the 10th schedule. But today, let's talk of this case. That notice was never moved.
No, according to you, notice is never put to vote. Only the resolution is always put to vote.
No, notice may not be moved at all. You may issue a notice, one member, and the one member is common in every assembly rule. In every in all rules of business of all assemblies in this country, including parliament, one member can move. See the consequence of this. He may move and he may not move it when the session comes up. He may just drop it. Or he may not get leave.
So he may serve the notice even not when the legislature is not in session.
That's right. He may not say so when it's not in session. And see the consequences. And they are doing it in every case now. We also did it in this case, but that's the objection my learned friend told me. But when we realized that he was going to disqualify us, kindly see what has happened is, that the speaker has only issued notice to us, that is the Congress, the MVA, for this qualification of their members. He has not even issued notice to them on our disqualification, till date. And then my learned friend's argument is, go to the speaker and have it decided there. What is going to be decided? He's not even issued notice in our matter.
8 months.
8 months have passed. That's why I said on undisputed facts, violation of the 10th schedule 21A and 21B is ex facie proof.
So really speaking, there are two thresholds. One is the 14-day notice.
Yes.
When you give the 14-day notice, the House doesn't have to be in session at all.
Yes, yes,
Because it can be even before the House Assembly.
yes.
And once the 14-day notice is given, then Rule 11, which is at page 40 of the statute compilation mandates,
Yes.
that thereafter, not later than within a period of 7 days,
Yeah.
thereafter, he will request the members who support the notice to rise.
Yes.
And if more than 29 people support it, then leave is granted to move the motion for.
He may still not move it. He may still not move it, Manoj. It's only leave that's granted.
Right.
So member may not move it.
So, Manoj, what will happen is, Manoj, that it will be fixed in the House within 7 days as an item on the agenda, resolution of moving. Manoj, till such time, the resolution is actually, Speaker is conducting his affairs in the Assembly. He is not prohibited either under the Constitution or the rules of business not to sit in that chair, even though there is a motion, there is a notice, and there is leave. He only vacates his chair at the time of voting. So, whereas the Assembly goes on, but the 10th schedule is paused, constitutionally paused by this judgment.
And it is after leave is granted that the motion has to be then taken up within a period of 7 days.
That's right.
So the first threshold really, I was just reading Rule 11, says that the motion to remove the speaker is to be given, of which 14 days notice is required under Article 179. That's the Article 179 threshold.
That's correct.
That is given. Then as soon as maybe after the expiry of that 14 days notice period, it would be read to the Assembly by the Speaker. The Speaker said, well, those who are in favor should rise. If 29 people rise, then leave is granted.
Yes.
And then within 7 days thereafter, a motion
Absolutely.
to remove the...
That's the process.
That's the process.
That's the process.
Part of it is constitutional, the 14 days requirement. But the rest of it is legislative assembly procedure. Of course, that's also rules made under the Constitution.
That's correct.
Now, Nebium says that the moment the notice is given by an individual,
Yeah.
you are then disabled. The speaker is disabled from functioning.
As a tribunal, not otherwise in the Assembly.
He performs all his...
All his functions in the Assembly. So how can you have an interpretation of the Constitution where the Speaker against whom there is a notice for removal functions in the Assembly but can't function under the 10th schedule?
So according to you, at what point of time is the disability attached to the speaker?
There is no disability.
There's no disability according to you.
No.
Even after the 29 threshold is crossed and leave is granted to move a resolution, according to you, there is no...
Still can't be, Mother. Still can't be because the resolution may never be moved.
Unless the resolution is put to motion, put to vote.
Exactly. And Mother, the reason is why there cannot be no hiatus. Because Mother, there must be somebody in the tribunal to deal with disqualification petition. So you can't say that between the leave and the resolution he should not function. Because the Constitution doesn't allow a pause for us in the functioning of constitutional authorities.
Once leave is granted, Mr. Sibal, the discretion to move the motion is still with the member who is moving the motion.
Yes.
So he may not move the motion at all.
Do not move it.
Is it that after the leave is granted within certain days, the motion is to be moved?
7 days. 7 days. 7 days.
7 days.
Suppose it is not moved by the concerned, it will lapse.
But if he stands by his motion, the speaker has no option but to move it within 7
Then
days.
Article 181 says you must actually move from the chair, becoming the... Well, then what happens? Very interesting. The
Can we just see, let's keep never mind.
Yeah,
Let's look at the Constitution for
Yes. 179.
It's always better to apply our knowledge.
Always better. I agree.
And Mr. Sibal, possibly this line of argument of yours is also buttressed by 2B of the 10th schedule, which says if he votes or abstains from voting in such house, contrary to the direction issued by the political party to which he belongs, or by any person or authority authorized by it in this behalf.
That's correct.
So the whip is really a person who is authorized by the political party.
That's correct. That's how it functions, Mullah. That's how.
Because the direction has to be given by the political party. You can't keep on giving a direction. It's a larger body.
Yeah, that's right.
So therefore, it delegates its power and it authorizes a person who will then issue a direction on which way to vote in the assembly.
In matter when it came up before the Law Commission, it will be disastrous for democracy, disastrous for the country if the legislature party is allowed to act independent of the political party.
So the actual whip, without, it says, or by any person or authority authorized by it in the
I read that.
Yes. So the party really nominates or authorizes a person.
That's correct.
And the act of defection lies in voting or abstaining from voting contrary to a direction given by the party or by that person.
Because I want to ask myself, supposing there's a bill in Parliament, the legislative party on its own can't decide what the position will be.
Right.
It cannot. Naturally, there'll have to be consultation with the party because they are not living in a side, they're not acting as a separate entity.
They are really the voice of the party in Parliament or the state legislature.
That's correct.
It's the political party.
The genus is the party, they are the species.